Good morning, good evening, good afternoon, everyone. On behalf of the Asia Society Policy Institute, we're delighted to host a program today to discuss a relevant and increasingly urgent issue in the trade world, and that is how to best discipline in the growing use of industrial subsidies and other financial assistance, and also to discuss, is the WTO, the World Trade Organization, up to this task? The WTO agreement on subsidies and countervailing measures goes all the way back to 1995. It's over 25 years old and really hasn't been updated since then. But meanwhile, the world has seen a sharp rise in the use of subsidies, particularly by non-market economies. And furthermore, we are seeing the scale, the reach, the sophistication, and the market distorting effects of these subsidies really wreak havoc on the multilateral trading system. And if things weren't complicated enough, they're further complicated by the types of government assistance in this COVID world being doled out by various governments around the world as governments increase their spending to trigger economic growth. In recent months, we've also seen increased interest in subsidies reform and strengthening the rules in this area. The recently concluded investment deal between Europe and China touches on transparency and state-owned enterprises and subsidies. The USTR National Trade Estimates Report issued at the end of last month puts a spotlight on unfair subsidies, particularly those leading to overcapacity. The new Director General of the WTO, Dr. Ngozi, has raised the prospect for a WTO work program in this area. And the G7 trade ministers that recently met at the end of last month talked about collective action to chart a way forward to address these issues. We've brought together a great group of folks to discuss the way forward on this pressing issue with a focus on whether the WTO is up to this challenge. The way the event will proceed is I will start with a moderated discussion with Clarisse Morgan, who is Director of the Rules Division of the WTO Secretariat. She's been with the Secretariat for many years, almost as long as since the WTO was created, is a real expert in this area. We'll have time for some questions for her as well. And then we'll turn to a panel of three other trade experts, and I'll introduce them once we're at that part of the program. I would urge all of you to use the question and answer function at the bottom of your screen. We will welcome your questions both for Clarisse and then for the panel as well. So with that, let me welcome Clarisse Morgan, and let's start our discussion, Clarisse. I thought it might be good, and I know it's always dangerous to ask an open-ended question like this when we only really have a half an hour for discussion. But can you just share with us in just very general terms kind of the core features of the WTO agreement on subsidies and countervailing measures? And then maybe just talk a bit on which areas have been identified through discussions where improvements may be warranted. Over to you, Clarisse.
Okay, thanks a lot, Wendy. And it's really a pleasure to be here. Yeah, I mean, I could go on and on at great length about what does the subsidies agreement have in it. But in very simple terms, the most general terms, it's sort of a two-track agreement. It contains the multilateral rules that governments should follow when providing subsidies. And it also contains multilateral rules for the use by WTO members of countervailing measures on subsidized imported goods. So there are these two tracks. I'll be talking mainly about the subsidies side of things than the countervail side. I would say that if you think about, in general, what are those rules about? Well, there are two basic categories of subsidies covered by the agreement, those that are prohibited and those that are called actionable. So the prohibited ones are directly trade distortive. Those are subsidies contingent on exporting or on the use of domestic over imported goods. The actionable ones are other measures that meet the definition of a subsidy and that are specific. They're allowed, but if they cause adverse effects, then they could be countervailed or subject to multilateral adverse effects disciplines. And there's a common set of provisions covering both of these tracks, which mainly have to do with the definitional provisions about what is a subsidy, what is specificity. And these areas have been the subject of quite a lot of disputes, all the elements. And just briefly to say, a subsidy is a financial contribution, a transfer of something of value by a government with a kind of an interesting definition, which includes a so-called public body. That financial contribution should confer a benefit to the recipient. And that is, how do you know if there's a benefit? You look at the market benchmark for what's the value of that? What would the value of that transfer be on the market? And then to be covered by the agreement, the subsidy needs to be specific. So somehow targeted or access limited to certain enterprises, certain regions, certain industries, or also the prohibited subsidies are by definition specific. So that's very broadly what does the agreement do, especially on the subsidy discipline side. And areas that have been identified, and much of this is in the work of the Trilateral Initiative among the US, Japan, and the EU, certain new prohibitions, some subsidies that are considered by these proponents to be so distortive that they think they should be subject to new prohibitions, things like unlimited guarantees, subsidies for insolvent companies, subsidies for uncreditworthy enterprises where there's creation of overcapacity, and some direct forgiveness of debt. And then others where they're consider there should be a reversal of a burden of proof, that it should be, the onus should be on the subsidizer to demonstrate that their subsidies are not causing distortions. There's also a big emphasis on improving transparency. That's another area which is closely linked to how the disciplines function, with a proposal that those who don't provide transparency, notify their subsidies, should be subject to pretty stringent penalties, including prohibition unless, under certain circumstances, unless written information is provided. And then another one is benchmarks. This whole question of how do you know if a benefit exists? What's the proper market comparison that you should be looking at? Particularly where there are allegations that the market in a country may be distorted because of the heavy presence of the government as an actor in that market. If the government, for example, is a predominant supplier of an input, can you find a price that's actually a market price there to determine if there's a benefit? So that's another area where there's some attention. And then finally, this question of public body that I alluded to, a subsidy is a government act, and it can be the government as such, very obviously identified, a government agency or a branch. But there are then, in the agreement, there's a reference to a public body that is also considered to be part of the government and equivalent to government for purposes of providing a subsidy. And this has been the subject of a lot of dispute settlement at the WTO. And at least the trilateral group is very concerned that the interpretation of what is a public body that came from the appellate body of the WTO was too narrow, and then it thus let escape from potential disciplines quite a lot of activity that they consider maybe should be subject to the disciplines. And so there's a very active debate about how should public body be defined, although at least the trilateral group has not yet settled on a consensus there. So I'll stop there. I hope that wasn't too long, Wendy. Thanks.
No, that was a great overview. And I think what you've underscored is that there are a myriad of issues that people have put on the table. And when you look at strengthening this agreement, there are lots of different strands that require attention. Just a quick question for you. I mean, there is a committee established that meets regularly, I guess, on the operation of this agreement. In those committee meetings, do they actually talk about some of the issues that you've mentioned on the table for possible strengthening, just like in a discussion mode, not in a negotiation mode?
Well, I would say certainly the issue of transparency and the pretty poor record of member countries notifying their subsidies is a frequently returned to theme that comes up. Also, questions of the potential contribution of subsidies to creation of excess capacity is a theme that comes up. And the way that these issues arise is that members with an interest will inscribe them on the agenda and may circulate a paper for discussion. There have been a series of counter notifications where a given member may say, well, country X has not done a full job of notifying their subsidies. I'd like to put these issues before the committee as well to see whether we can get some information. So there's quite an active discussion, not really directly with a view to thinking about new rulemaking, but about issues that are arising that members consider to be of interest or concern. So yeah, some of these issues, at least kind of tangentially or obliquely, do come into the committee as such.
Mm-hmm. And how about dispute settlement activity under this agreement? I mean, are there more dispute cases in this area than other areas in relative terms? Are most of the disputes in this area with respect to like countervailing duty procedures versus substance? I mean, can you just give us a feel for dispute settlement activity in this area? Hello? Oh.
Sorry, I forgot to unmute. Yes. Well, first of all, sort of in terms of dispute settlement in the WTO overall, what we call the rules area issues account for about half of all disputes.
But that's broad,
and
subsidies, right?
That's broad. That's sort of anti-dumping, countervail, subsidies, et cetera. Of those, anti-dumping is the most frequent, and by number of cases, countervail comes second in the rules area, and then the subsidies disciplines. That being said, those subsidy discipline cases have been some very big and important cases. They include the aircraft cases, the Boeing Airbus aircraft cases, the Embraer Bombardier cases, the Upland Cotton case, foreign sales corporations, shipbuilding subsidy cases, and the case brought by the U.S. on Indian export subsidies. So some pretty big cases. And of course, the Boeing Airbus has been the longest running dispute of the WTO system. I think only the bananas dispute, which started in the GATT days, it has gone longer or went longer. So there is quite a lot of activity, and things like the Airbus case and the Boeing case raised many issues. So
it went on for many years.
And went on for many years.
Yeah.
And I would say in terms of issues, I don't know if you'd like me to talk a little bit about some of the issues that have been sort of dealt with, and I'll try to keep it short. Public body, which I mentioned, the finding by the appellate body that has been contentious is that the appellate body said to be a public body, an entity has to possess, exercise, or be vested with governmental authority. And I think they initially said, sort of like policing and this sort of thing in terms of governmental type functions. Before that, there had been some panels which had said a public body is an entity controlled by the government. So a simpler test. And over time, the appellate body has been called to, again, weigh in on this question in a series of disputes. And there was a little bit of evolution, it seemed, in terms of exactly what did they mean by the test and how would it be applied. And then the final step there is that I think in the last appellate body case, before there were no further appellate body members for the time being, there was even a dissent by one appellate body member saying, actually, this is getting too complicated. It should be control. So there's quite a lot of government control. So there's been quite a lot of back and forth about this. And, that's a pretty key issue because, depending on how broad or narrow is the definition of what's a public body, then a bunch of behavior is either potentially covered by the disciplines or completely outside. And I think there it's important to remember that, because financial contribution, benefit, and specificity are independent conditions, calling something a public body doesn't mean that everything it does is a subsidy. It just means that, if there were a benefit, if there were specificity, it would be covered by the agreement, et cetera, et cetera. So that's one that's pretty important. Briefly on some of the others, financial contribution, there have been some interesting ones where, questions of provision of input products at low prices has been a recurring theme for a long time. And there had been
downstream inputs.
Exactly. Yeah. So, raw materials for production of further manufactured goods. And, if those are provided at low cost through subsidization, then obviously there's a subsidy there, but perhaps there's a government policy that doesn't necessarily look like a subsidy that might also have the effect of increasing the domestic supply or reducing the price. And, the sort of the line between what of that could be called a financial contribution and potentially a subsidy has been debated. And one issue was, well, what about an export restraint? And there has been a finding that's, well, no, that wouldn't really do it because you couldn't quite stretch the concept of a government entrusting or directing that far to encompass that. Entrustment or direction of providing a good would be the issue there. So this is a pretty important area where there has been a lot of activity, this whole question of input pricing. And it does kind of bump up against some of the anti-dumping stuff as well, where you have, distorted input prices giving rise to certain cost calculation methodologies and things, which also have come under some scrutiny at the WTO. Benefit, as I said, it's really about the benchmarks and whether government intervention creates distortions that make finding a benchmark within a country possible, or can you then go outside of the country? And while in principle you can, there's a lot of controversy about the circumstances in which you can look outside of the country where the subsidy is provided to find a benchmark. Questions of export subsidies and what is contingency on exportation to make a subsidy an export subsidy has been heavily litigated, and there have been a couple of different tests that have emerged over the years. And a lot of attention also on the so-called import substitution subsidies. Those are the ones that are contingent on the use of domestic goods. What does use mean? And if you have, for example, a vertically integrated manufacturing process, as you continue to build from scratch something, does it become a domestic good in the manufacturing process? And then does the subsidy become contingent upon the use of your semi-manufactured product as you push it through the chain? And quite a lot on specificity, various issues related to what does it mean to limit access of a subsidy to certain recipients, whether in a geographic area, whether to certain enterprises, industries, and that there are a lot of quite detailed rules about this, and so it becomes all very complex, and order of analysis and these kinds of things sort of come into play. And then the last area is about the serious prejudice and adverse effects side of things, where it's a panel that's looking at something a little bit similar to an injury determination in a domestic trade remedies case. Panels don't normally have access to the kinds of information that domestic investigating authorities do. And there is an information gathering mechanism in the subsidies agreement to address this issue. And that the use of that has become kind of complicated because it's become contentious whether it's an automatic right or not. And we also have had in that context some consideration of what does it mean to withdraw a subsidy or remove its adverse effects, which is the remedy for, say, serious prejudice cases, and do the benefits time out after a while, as would be the case in a countervailing duty situation. So, that is just a handful of the many issues, but hopefully that gives a flavor of what we sometimes deal with.
I can see why your director's so busy. Can we just change gears then? Because we have about, 10, 15 more minutes for our discussion. Yeah. And that is, can we just talk a little about what a negotiation on strengthening the subsidies agreement would look like? In other words, how does that get off the ground? What are the major challenges? Can any country just put up their flag and say, we don't want this to go forward and that's the end? Can you give us a sense of how something like this could start? Would it be the U.S. or other countries putting a proposal on the table and asking for the initiation of negotiations?
Yeah, well, I think a little bit, yes, to that question, but perhaps it's more than that to really get the ball rolling. Is I think generally negotiations start when more than one member come together, find a common position, and then they start to do a bunch of outreach to try to get more and more supporters. And, we've seen that sort of a process with these joint statement initiatives that got sort of launched at the Buenos Aires Ministerial.
The plurilaterals, right?
Yeah, I mean, and yeah, exactly. And so I think they're hoping to end up in a multilateral negotiation. And so they've just sort of accumulated more and more support, and they've gotten pretty active. And so I think that, if you wanted to get something going on subsidies, it would be the same thing. That those who are very interested would have to come together, try to find common positions, and then try to socialize it and get more, more supporters. Now, if you're going to really launch a multilateral negotiation, I think it's a consensus-based decision that's needed. And what we've had in the past have been these big rounds, in the GATT days, and then, of course, the Doha round, where you have a whole package of different issues kind of bundled together, and different members have different interests in the different issues, and somehow it sort of all moves ahead. I know Ron is a veteran of Uruguay and Doha rounds, so has some firsthand experience in all that process. And where we are right now is I don't know to what extent any of the members would be thinking about that kind of a process or pursuing kind of more individual work streams, and then how that would all translate itself into a potential move forward in a multilateral way. I think that, we're just going to have to watch the space and see what would the interested members do and how would they proceed. But in general, they would basically just try to gather as much support as possible, and then try to sell it to those who would be perhaps more reluctant, and see if they could find ways to get them on board with I don't know, other arguments.
And how would a plurilateral in this area work, in that, once you offer to discipline your subsidies, you're doing it for everyone by definition? I mean, is it a question of who joins the plurilateral then, and, achieving a critical mass, or does it just not make sense?
I mean, I'm not very familiar. I haven't got any real experience with plurilaterals, but yeah, I think that it's always a question of critical mass. And I think in subsidies, the sort of received wisdom is that, it's much more effective if you have everybody on board, obviously, because then you have everyone kind of at the same time reducing their subsidy levels and taking on similar commitments. But that doesn't mean that if interested members were so inclined, they could always think about that as a possible way forward. So beyond that, I can't really speculate.
One of the criticisms that we hear about launching a WTO negotiation in this area and frankly other areas is that negotiations can take a long, long time, and these issues are just pressing. I read somewhere, I don't even know if it's true, but the fish subsidies negotiations, which are hopefully in their final leg before conclusion, have been ongoing for 19 years. How is this a big challenge in terms of trying to develop a consensus and to keep people interested and trying to deliver a result in an area that's only getting more and more complicated each year?
Mm-hmm. Yeah, no, it is true. I mean, the fish negotiations were started as part of the Doha round, which did begin. It actually started activity in early 2002. So yeah, it's been a long time. And I don't really have an answer for, what could make things go faster. It is true that things, with so many members now, 164 members, each with their own issues and interests and certainly concerns. It's perhaps harder than it used to be to get everybody who needs to be on board. And the membership is very diverse. You've got the countries like the US and the EU and Canada and those guys. Then you have the bigger developing countries, China, Brazil, India's, and then you have the really small ones like the Pacific Island countries. And then you have the LDC group, the least developed. So, it's very, very diverse. And I don't know what the solution is to try to, have a situation where everyone sees enough in it for them offensively that they're willing to make the push forward and also take on the commitments that they would have to take to get a deal done. And I think that's what's needed. So,
okay, and then just last question, and just I'm pulling together two questions from the audience, and that is the relationship between climate change and subsidies. Can you just explain how the two overlap and how rules in this area can help or harm the broader climate change objectives? Yeah.
I think it's like many other policy areas. Certainly, there is more and more talk of trying to put disciplines on fossil fuel subsidies. And so one can make an argument, if you're subsidizing the use of fossil fuels versus renewables, you may be adversely affecting climate change. Whereas if you're promoting through subsidies and other means renewables, maybe you're doing something positive. So I think, there is a debate on this topic. And I would recall also that the subsidies agreement, when it first came into force, actually did have a provision, a non-actionable subsidies provision. And one of the categories of non-actionable subsidies were certain, I would say, pretty narrowly defined environmental improvement subsidies, which were deemed to be both, for the public good and also unlikely to be trade distortive, and so worthy of being protected from challenge, either through countervail or through, serious prejudice type cases. So there's clearly, I think there's clearly a lot of interplay there, but it can really cut either way depending upon what the subsidies are actually doing.
Okay, I think that looks clearly going to be an area there will probably be more and more interest and discussion. But you're right, there's two sides to this coin as well.
Yeah.
Well, with that, just really want to thank you, Clarisse. This has been great. You've set the table. We appreciate you taking the time from Geneva, and thanks so much. And now I'd like to turn to our panel to continue this discussion. If I can ask then our panelists to join us, to put their screens on. Okay, great. So for the next 45 minutes, we'll have a discussion with Hosuk Lee-Makiyama, Ron Lorentzen, and Clete Willems, all good friends of mine, all trade experts, and I think folks that are going to make this conversation interesting and hopefully a bit fast moving if we can. Let me just start with just brief introductions. Hosuk Lee-Makiyama is the director of the European Center for International Political Economy. Prior to that, he was a senior advisor of the Swedish Ministry of Foreign Affairs and a representative of Sweden to the WTO and UN. Ron Lorentzen is now the senior international trade advisor at the law firm of Kelley Drye. He's had a long and distinguished government career, both at the Department of Commerce and at USTR. And I think Clarisse alluded to this earlier, that you actually worked on the subsidies negotiations during the Uruguay round and I guess during the Doha round, even though those and other negotiations didn't go anywhere. And finally, Clete Willems, who's now a partner at Akin Gump. Before that, he was deputy assistant to the president for international economics and was a longtime trade negotiator and WTO litigator at USTR, including serving in Geneva. And I would just say here, he recently published a paper at the Atlantic Council on WTO reform, which touches on this area as well, but is much broader. So with that, let me turn to the panel. And the first question I'd like to ask is that you've heard what Clarisse said about kind of the deficiencies of the WTO subsidies agreement. Would you agree with her assessment? And from your point of view, where are the biggest roadblocks or the biggest areas of concern? Hosuk, maybe I can start with you.
Wow, well, that's a really big question, but
right, and you only have 1 minute.
Yeah, no, I think I'll let me perhaps look at the EU, US, and Japan trilateral, and perhaps look at what are the issues it is trying to address, and it is effectively large-scale subsidies that are aimed at, for example, unlimited guarantees, subsidies of insolvencies of companies that will never return to profit, and debt forgiveness. In other words, a broader definition of subsidies.
Okay, before we get into this, can you just explain to the audience the trilateral, what it is? And
Sure. Since 2017, EU, Japan, and the US has been engaged in a discussion on both a ministerial technical level to draw up both new rules, but also coordinate some position on important issues like overcapacities and subsidies. And in 2020, January, a year ago, the three actually managed to create a ministerial joint statement, and that would essentially draw up a roadmap and the principles regarding what the new rules on subsidies on ASEM upgrade should include. And as I said, the one is, of course, the new definition of what subsidies are, because we are now looking at new methods or techniques of subsidization, which were really not envisaged, or at least if they were envisaged, they would not appear in the large scale as we see now today, which were really not a commonplace in 1995. But also when it comes to public bodies that I think Clarisse really well illustrated, which also comes to the question about what is a public subsidy, because we didn't envisage, for example, a state-controlled bank in the form of SOE in the way in 1995 that we can see today. And also procedural issues, for example, like burden of proof. There is an abysmal record when it comes to notification of subsidies. So we don't even know that the playing field is unleveled. And also, proving subsidies is extremely difficult, especially in countries without rule of law. And for that reason, also, the CVD instrument has been extremely either difficult or a reluctant diplomatic tool to address with subsidies as well. So you can really see that there are needs to actually update the rule book, largely because the scale of a state capitalist system, like, for example, China, couldn't be envisaged. The countries that we saw back in 1995 of that kind of model didn't have the ability to scale in the way that China does.
Ron, since you were there, I mean, do you agree with that assessment that the world has changed dramatically since, the negotiation of the existing subsidies agreement?
Well, I think it's fair to say that it has, but I don't know that that's unique to the subsidies agreement in the WTO context. But, Clarisse gave a good litany of all of the issues and debates and disputes that have arisen over time. And that's natural that those things need clarification in any subsequent negotiation. The thing that strikes me, and Hosuk touched on this, is that, the subsidies agreement was crafted with the basic premise of a backdrop of a traditional market economy. So that's how you identify and measure whether a subsidy is being provided by a government by virtue to what the market commercial context is in that jurisdiction. And with the growth in commercial power of what I'll call non-market economies, such as China, but not limited to China, you have a whole set of issues about how well the current rules fit with those new dynamics and that new construct. And I would even go so far as to say, it's not just a question of, is the definition of state or state controlled broad enough, but we may need to think about whether in certain contexts, the role of a governing party is actually a relevant consideration because of, for example, in China, the nature of how the party acts as the state without maybe always officially being the state. And the third area that I think is an argument for looking at the subsidy rules is that, you mentioned the sort of uptick in government spending to deal with economic recovery dimensions of the COVID pandemic. You also, in your discussion with Clarisse, talked about climate change. And I think if this administration is serious about its ambitions in conjunction with other countries in the climate area, it will need to think carefully about how the subsidy rules affect the development of programs. So not just do we need to change the trade rules, but do we need to be informed by the direction of trade rule reform and determining how to structure support programs to encourage adaptation of the economy under the new climate conditions. And then lastly, I'd mention the fact that this administration has produced a lot of paperwork in the past couple of months about the need to improve our economic and technological competitiveness. And a lot of those ideas have to do with government role in stimulating innovation and research and development. And there's a certain amount of bipartisan interest in those ideas, so it's not just the Biden administration. That also implicates subsidy rules. One of those so-called non-actionable subsidy categories that lapsed had to do with government support for commercial research and development. And there were a set of intricate rules about what was basic research versus what was at the lower commercial end of the R&D spectrum. And all of those things kind of need to be thought through, not just in terms of how we might change the international rules on the trade regime, but also what government programs ought to look like in order to diminish their possibility of distorting markets and being subject to actions by our trading partners.
Wendy, if I may, I'd like to come in and second what Ron was just saying, because I think he's absolutely right. Because even between the very like-minded market economy-driven entities like EU, Japan, and the US, you would have remits that is defined by what we do. Europe has a very comprehensive and horizontal, non-discriminatory R&D funding, but we also have a policy bank, just like China, European Investment Bank. And if you speak to anyone in the US aviation industry, they'll tell you it is even worse than China. I'm not going to pass my judgment on that. But also some of the items that we're looking at, for example, in telecoms, the planned subsidies in the US and Japan and UK is exactly the kind of measure that China itself was engaged in and was guilty of when it developed its national standard for 3G. Closed door subsidization of unique standards in order to create local players. So the question is, what is actually the definition of what is actually a desirable and non-desirable subsidy is really in the eyes of the national interest here.
Clete, You look like you've got a lot to say. And the lot's been put on the table, so go for it.
There's a lot here. I'm going to do this, Wendy. I'm going to start with the first question because I wanted to make a couple comments on there that I think are important for the audience. And then we can turn perhaps at some point later to this broader debate about how changes to the subsidies agreement might affect the policy space in the US and Europe and others. So just sort of starting with the first question, which was looking at, what are the most important things from the perspective of an American who used to work for the US government that we need to fix with the agreement. I'm gonna pick quickly, and some of this was already touched on, but let me try to be very precise here. I'm gonna pick out 3 things from the trilateral that I think are important, both for substance, but also for some symbolic reasons, and showing that we can get our arms around some of the problems with the international trading system. So the first one, which has been alluded to, is just sort of the list of subsidies, the nature, what are the list of prohibited subsidies that we want to deal with. And I do think that's important, because the world has changed. We are dealing with China with large-scale industrial subsidies. And some of the things that we were trying to capture in the trilateral were these large-scale subsidies that were propping up zombie industries that really had nothing to do with reforming those industries, but just continually pumping money into them to prop them up. And I think that's symbolically important because it also gets at the steel issue, which I think has sort of been the manifestation of what is our problem with Chinese policy. I think steel is a perfect example where excess capacity has caused global distortions. And so updating the list of prohibited subsidies would be good from a substantive standpoint, but would also show we can tackle that issue.
So the trilateral then adds it just expands the list of 2.
Yeah, they have 4 new additions to it, which would, in many respects, is intended to deal with these large-scale industrial subsidies like you see in the steel sector. The second portion of the trilateral is on notifications and really making those binding and having members actually notify their subsidies, which I think Ron alluded to is so important so we understand what's going on globally. So we understand the playing field for our companies so we can actually challenge these things as appropriate at the WTO or using our tools of Countervail. So, but it's also important because I think it's a cross-cutting issue that is not only relevant to the subsidies agreement. I mean, this is the entire foundation of one of the pillars of the WTO on monitoring. And so across all of the agreements, we need to do a better job of ensuring countries make those notifications and penalize them if they don't. And I do think that doing it here would be symbolic to say we can do it across the WTO, which is going to be a necessary ingredient for broader reform. The third one, public body. And this is important from a substantive standpoint because it has undermined our ability to countervail, SOEs providing, subsidies in the market, which is just a huge problem with China on the merits. But also, I think it's substantively important because it shows that we can actually reverse something that was done at the WTO. We have this very troubling problem where once the appellate body deems it as such, that is the world that we live in forever after, whether or not we agreed upon that as members. And so to actually go back and say, you know what, you got it wrong, here's what the definition would be hugely important when it comes to looking at reforming the dispute settlement system more broadly. And I could spend a whole session teeing off on why public body was wrong, but let me just say, having the appellate body bring in draft articles of state responsibility that were never agreed by anyone, let alone the WTO, and saying that's the foundation of our definition of what a public body is, really represents everything that the U.S. has been complaining about the appellate body for years. And so I think that one is really important. So I'll stop there just to put a point on what I think are 3 things that are critical from the trilateral.
Okay, just to follow up on public body for a minute and the trilateral, my understanding is the 3 parties weren't able yet to come up with an agreed upon definition for public body. Is that correct? And do you know, is it just because it just needs a little more work, or are there fundamental difference in views here?
So I'll give the U.S. perspective, and then I see Hosuk is like, I'm going to give the European one. But look, I mean, from the U.S. perspective, we've been very transparent about what we think is a definition. We've included it in a bunch of WTO submissions. USTR put out a report last year on the appellate body where it had a whole section on public body talking about what it thinks an appropriate definition would be. So it was alluded to before, there was a dissent talking about control. I mean, so I think from the US perspective, there's some pretty clear ideas about what that definition could be. The US angle might be that we haven't yet gotten the Europeans on the same page, but I'll let Hosuk explain why that is or is not correct.
Well, all I can say is, well, I'll make 2 points. I mean, it is indeed true that there is a different ideas about what public body is. And especially, I mean, looking at from a self-critical point of view, for example, in Europe, we have several state-owned banks, and state participation, at least on a subcentral level in some of the European countries, including Germany, is not that far off from, let's say, an economy like China, if you actually count it by GDP. I'll give you that. But also, I mean, the US has also a certain number of loans, for example, by the SBA, the Small Business Administration, which we think is absolutely fair, but from the perspective of someone else's, it's going to look very different. But my main point is not going to be really about the definition of public bodies, but actually the process. The question is, in the trilateral process, if you have the intention of engaging the rest of the membership on, let's say, on a very strong, this is the direction we need to go, almost like an existential, I don't want to use the word take it or leave it, but very much that these are the principles that we have to be able to stand by. The question is, how ready do you want to make the proposal within the format of just 3? And especially if you have the intention of engaging the rest of the membership. I think this is a very vital point here, in the sense that China is a very different entity, let's say, than India, that basically says no to everything. China is at least engaging, not enough from anyone's point of view, I guess, and including China's own perhaps. But the real question here is, if we are going to create actually a new, even whether it's a trilateral or a new structure, we can have that discussion later, but fundamentally, giving entities like China to be rule makers rather than rule takers, I think is a very important principal point. And this is just my personal point of view, that it may not be desirable for actually the proposals to be too developed just amongst the 3.
So Ron, I'm going to turn to you here because I know you have views on this, particularly when you were in the government, you worked on the OECD steel overcapacity dialogue. How do you react to what Hosuk said? I mean, when do you bring China into the tent? Is it important to bring them in sooner rather than later? And then I would just ask for you, given your expertise, what are your views on this trilateral initiative? Do you think, looking where we are now, and now it's, we have the paper from a year ago, January, is that document ambitious enough? Does it need to be updated, given what's transpired in the past 15 months?
Well, I don't want to range too far afield, but I guess my reactions to this sort of pull me there, because I would say I think the contribution by the trilateral initiative is very important for two reasons, 2 basic reasons. One, for the examples that Clete went through. I mean, it represents a lot of spade work in terms of how one appreciates the distortive effect of government policies that the subsidies agreement has not effectively been able to capture so far, while still kind of remaining within the contours of the basic subsidy rules. And secondly, it has brought in, the US, the EU, and Japan. Now, Hosuk makes a fair point about, there's going to be disputes even within that little family. What happens when you broaden the picture to a larger range of members of the WTO? I tend to feel that on the capacity side of things, there's a need for our government and maybe others to take a look at an optional sort of approach where, and this might be like a bilateral thing with China, where if you look at particular sectors, and I tend to be of the view that given the direction that the Xi regime is moving now, we can't reasonably expect them to return to the halcyon days of economic reforms in terms of a market model. So where does that leave us? You might be able to get some agreement on additional disciplines and certain subsidies, but it might also be the case where you can reach a managed trade agreement with China about what happens to their excess capacity and their excess production. And until the day is reached where they are comfortable adopting some better disciplines on what caused those problems to develop, they at least need to be responsible to prevent the consequences from adversely affecting their trading partners. That's sort of a practical approach that many sort of trade policy thinkers might be uncomfortable with because it does.
Are you advocating like voluntary restraint agreements?
Yeah, production restraints, that sort of thing. And I'm not saying that's an ideal solution, but if the problem we're trying to solve right now is indeed so time critical and so massive, you may need to resort to that for the time being, and then work on the longer term reforms. I think I've been trying to think about, how do you create a conversation so that you're able to distinguish all the legitimate differences of view about what the state's role in the economy is in the range of what I'll call traditional market economies, and Hosuk has touched upon some examples there, and what I think is a distinctly different in form, if not impact, scenario that exists in a non-market economy, where the party's presence in the economy is so pervasive, both implicitly and explicitly, that it's really hard to sort of find a subsidy as we know it in that context, even though you can find lots of distortions. And to me, that's an argument for maybe in a WTO context or otherwise, looking at a range of disciplines that might help sort of hem the distortive effects in, whether it's competition policy or looking again at the TRIMS agreement or any number of things that would kind of allow the participants to sort of see, okay, how can we manage, if not diminish, the distortions that exist in the global economy as a result of these different systems working with one another? Because I think China has to be part of the solution at the end of the day, but I'm reluctant to allow them to dictate the menu. And we need to have an ability to sort of coexist for some period of time while working on the longer term problems. And that, that goes with equal force to the question of climate adaptation and what sort of role governments would play in that area. But I think, if we can't come to terms with the differences that exist in China's economy versus a developing economy where the state plays a significant role in certain economic development aspects, then we'll have a lot of problems because effectively China's been able to hide behind, the old conventional term is hide behind the skirts of a lot of other countries in terms of this notion of how one is able to discipline and yet acknowledge that in some cases governments play roles in economic development. From a WTO perspective, it should be about how do you diminish or eliminate the distortions, but we have to realize that when you talk about something like subsidies, that's all about the intersection between domestic policies and international trade rules.
Clete, I'm going to turn to you. A lot on the table. So share, managed trade, should we be negotiating bilaterally? Does rulemaking in the WTO, even if we were successful, will it make a difference?
So the subsidies issue, and I've struggled with this as I was looking at a sort of a broader WTO reform proposal. I really struggled with the subsidies issue almost more than any, because it just isn't as conducive to a plurilateral framework as others. Because at some level, what a subsidies agreement is all about is sort of, theoretically tying your own hands and your ability to provide assistance in your economy. And if China is not a member of that, I think in many ways it misses the point. So I do think that the U.S. for that reason, needs to work with EU and Japan, needs to expand that list and really try to bring it into the WTO. I think it's long overdue. I think at some point that effort, runs the risk of becoming a failed effort. I mean, we've been going for 4 years. We don't have text and public body. This administration, I think, credit to them, has really talked about the need to work better with allies to deal with some of these problems. They need to get this done, and they need to get it done quickly. And then even if it fails in the WTO context, at least we've tried, and then we understand that we're going to, the WTO may not be the right place at this moment in time for us to solve problems like this. But we need to get there to learn that lesson and then figure out where to go. Now, there are some things here that we, regardless of whether sort of the overall effort fails and updating the agreement fails, I still think that public body issue we need to try to deal with, in the WTO clearly, and maybe through some of the appellate body reform efforts. But I'm not, again, my level of optimism isn't super high, but at least if we got a broader range of countries to say these are principles that we all agree to, I do think that would be meaningful and would set us up, as Ron says, over the long term to put in place a paradigm that works for everyone. And I also agree with Ron, there may need to be short-term solutions as well. I'm not in a position where I'm going to go endorse voluntary restraint agreements at this point, but I hear what he's saying.
Can I just make a brief interjection about this notion of plurilateral agreements? And I agree with what Clete just said on the full range of his remarks. And I'm not one to diminish the obstacles, but one of the benefits of no longer being in the government is that I can be provocative and say crazy things, and I won't have too many consequences to pay. So in the olden days, the Tokyo Round Subsidies Agreement was in effect a plurilateral agreement, as some other Tokyo Round agreements were, because the basic trade-off was subsidy obligations for the members of that agreement, in return for which you received an injury test in countervailing duty cases. And there are other GATT rules that allowed the injury test to be applied, but just to speak in basic terms. So if you weren't in the Tokyo Round Subsidies Agreement and you weren't subject to these other sort of rules, you could be countervailed, your exports to another country could be countervailed without an injury test. So that was a benefit of being in the Tokyo Round Subsidies Agreement. Now, we don't have that luxury today because of how the system has evolved. But, and again, don't shoot me for saying this, but it seems to be conceptually, you could have a plurilateral agreement even on subsidies where more obligations are undertaken on certain more distortive subsidies, and you could have lesser obligations, even if they're not fully non-actionable, and other kind of subsidies that group of countries deems desirable to have, whether it's for climate change or emergency economic circumstances or what have you. I'm not advocating any particular kinds of subsidies there, but I think there is a way to construct an agreement that has additional obligations and some additional benefits that wouldn't be applicable to the whole membership. And that might be something worth thinking about.
Hosuk, do you think there's merit to that type of approach?
Well, maybe with a little bit of nuance. I'm actually a little bit scared by how like-minded we are in this group, and I try to think of actually something that to contradict the other two. But perhaps this is just a nuance to what Clete and Ron was saying, which is essentially that look, we do have an urgent political, not necessarily economic, but a political problem, and even under a context of the last 4 years and the relationship we've had and the frictions we had across the Atlantic, we could agree that yes, overcapacity is a huge problem for our political masters for whatever reason. And I think in the end, what we are looking at, it's not necessarily a plurilateral as a goal. It's not, I think plurilateral is just a process of actually arriving to where we need to be. And exactly for the reason that Ron was saying, that it is an instrument to identify the trade-offs that we need to actually find in order to get what we want on our offensive issues. And the joint offensive issues of the three is inevitably going to be around subsidies and the overcapacities. Now, I think it is inevitable that we are going towards a renegotiation of the WTO agreement. And I would like to remind everyone that even the WTO started as a plurilateral. Even the Marrakesh was a plurilateral from the beginning. Not just the subsidy disciplines under Tokyo, but also their whole multilateral creation was a plurilateral agreement from the beginning for a while that even coexisted with GATT. We tend to forget this, that there is an evolution between the plurilateral and the universal. And now subsidies are probably not going to be an issue where you can have a universal buy-in, but if you stand by these offensive principles, you can actually say that this has to be a part of the trade-off of the renegotiation that we are facing. And now we shouldn't also forget the fact that we are doing a number of things unilaterally and bilaterally. It doesn't have to be VERs, it doesn't have to be managed trade solutions, but there are also carve-outs that we can actually negotiate. That there are certain unilateral instruments that we need to have in place. And ASEAN is a great example of those carve-outs in terms of trade remedies. They were there in order to, a part of the bigger trade-off that we needed to negotiate. Now, there's nothing that says that we can have a new instrument like this within the domestic system that is allowed as an exception from the MFN. And this is how we could perhaps relieve some of the sectoral issues that we will inevitably have, not least in basic materials and steel.
Clete, if I can turn to you, just kind of more broadly, I mean, earlier there was a discussion that, our hands aren't clean, the EU hands aren't clean, and, we're maybe suggesting that, China may not be as big a problem as they are. Do you agree with that? Do you think the fact that governments now are pouring more money into the coffers because of COVID recovery, but also now to kind of prop up some industries and frankly invest in industries of the future, is this going to complicate the work going forward in this area?
Well, thanks, Wendy. I had been itching to get back to that topic, and I wanted to make sure we got through the other stuff first. And I think Hosuk is right. We do agree on a lot of things, and I think that they had great ideas, both him and Ron, on the plurilateral. But look, this is an area where I do have to disagree, I think, with some of the earlier remarks. And I think it's a false equivalence to compare some of the things that the US and the EU are doing or are contemplating doing with what has been going on in China for years. Just the scope and scale of the level of benefits that they provide to their industry is far beyond anything that we are talking about here. I think you have to keep in mind, and this is an economy that's 30 to 40% state-owned enterprises. And even the most ambitious folks on the Hill talking about things like industrial policy, this is far beyond their wildest imagination. So I think that's a huge differentiator. I also look at the fact that when you look at a lot of China's policies, and you look at the subsidies agreement, which is all about sort of adverse effects on other economies. A lot of what China has done is with the stated intention in their Made in China 2025 plan to dominate industries of the future, to hurt global competition. That is very clearly stated. That's very clearly outside the spirit of the subsidies agreement. And again, I don't see anything like that from the United States. Here, it's more about we need to make sure that we are remaining competitive when others are trying to distort the global economy. And if I could be even more specific, let's look at the China package right now that we're talking about on the Hill. A lot of attention is focused on the Endless Frontiers Act component of the legislation, which really is all about bolstering the National Science Foundation, more R&D, partnerships with universities, tech hubs, things like that, that are very different from the kinds of things that China's talking about. Semiconductor, the same thing. R&D spending is a huge component of what we're trying to do. And those aren't the kinds of things that we're complaining about broadly with China. It's propping up zombie industries, the steel sector, and then doing that with the sole intent of trying to dominate the global industry. And so I think it's a false equivalence. Now, we need to be careful. The area I will say I'm worried about is when we couple some of these big spending items with the Buy America type stuff, with the domestic content requirements. And that is the area where the US needs to be very careful not to become China as we try to outcompete China. Because China does have those elements of discrimination in many of its programs, and we need to avoid that. So again, I will say, I think it's a false equivalence when it comes to general spending, R&D, that kind of thing. Where in the US, I do think the critique needs to be examined, and where we need to be careful is when we couple it with discrimination through Buy America and other programs.
Okay, I would like now, we have 10 minutes left to kind of change gears a little, and that is to talk more about our domestic laws for the US, our countervailing duty law, and for Europe, what they're doing in this space. I was a member of the task force led by the Carnegie Institute about a foreign policy for the middle class. And in that report, one of the things we called for was modernizing our trade laws to better address the challenges we face, and specifically the countervailing duty law was mentioned. If indeed, we think that the WTO talks may never get off the ground, or if they do, they're going to take not just 19 years like the fisheries negotiations, but longer than that, are there things we should be doing to strengthen and broaden the scope, make our domestic laws more effective in addressing the types of subsidies that are hurting our companies and our workers? Who would like to take that? Ron, I'm going to ask you.
Sorry, I was having trouble unmuting myself. That's a very relevant question. It's a very difficult one. And the main difficulty in my mind is how one navigates the need to deal with new kinds of distortions that our commercial enterprises encounter in terms of imports into the US versus the limits of WTO rules. So if we're not going to care about WTO dispute settlement, then there's probably any number of things. I noticed one of the questions had to do with currency undervaluation and things like that. But all of those sort of what I'll call sort of edge of the border type approaches to subsidy issues in the countervail context always run the risk of being found inconsistent with our WTO obligations. And, sometimes it's not. Sometimes, it is a gray area that can be ruled in our favor, but that's the risk that's run. I think right now, the Congress has tended to sort of focus on the problems of efforts to circumvent existing duties, whether through evasion and that sort of thing. And those apply with equal force to dumping and countervail. There has been an ongoing interest in dealing with undervalued currencies. That's, in my mind, it's an important area in terms of distortion, or potentially in terms of distortion, but it can also be one where it's very hard to apply the subsidy rules because of specificity considerations that Clarisse was talking about, and how that transmits into a benefit for a particular industry. So, we'll see over time how well some of those things are tested. I think, from my perspective, it's always important to sort of make the laws more accessible to U.S. firms and workers that think that they need to consider using them in order to defend against injurious, unfairly traded imports. That's not necessarily a question of sort of revision in favor of, identifying new kinds of subsidies, but how do you maintain a fair, objective process, but also making it relatively quick and able to be administered by the folks at the enforcement agencies in a way that does that ensures that there's due process and full rights of participation.
Hosuk, can you share with us what the EU is doing in this area? Isn't this like part of their new policy toolbox? It's kind of strengthening their countervailing duty mechanisms?
Sure. I think this is actually a great example of how you can be innovative and the complementarity of the multi/plurilateral approach versus bilateral unilateral approaches that we just talked about. And also, I think it's the question you raised and Ron's answer is, I think, great, because it really shows that the subsidy question proves, at least conceptually, trade policy is an international dimension of very much of domestic disciplines like competition policy. And I think we need to recognize that, trade is not a panacea. And please don't quote me that outside of trade policy circles. But I mean, even the use of CVD has very undesirable effects. And if it's complaint-based, it turns into area and sectors that have very little industrial policy values at times. And EU has, for example, launched a case on copying paper. The future of a European value add is not based on copying paper. That I'm pretty sure about. So I think you can really see that as an alternative to trade policy, you can actually turn to domestic policy solutions in order to find answers to basically cross-border problems. And I think EU's white paper, which was launched last year, was actually published by the competition authority, the competition branch of the European Commission rather than trade, really shows how this complementary works. And it basically contains three elements. One is a new ex post investigative power for the competition authorities of the single market to look into subsidies ex post, just like it would look at abuse of dominant position, antitrust, or illegal state aid by an EU government. And actually, you can define distortion extremely broadly, because you're not just talking about trade distortion. Now you're talking about market distortion, which has a slightly wider scope that could cover for all market situation. And also it opens up a new toolbox of punitive sanctions, not just tariffs or trade restriction, but also structure and behavior remedies, which gives you access to much broader solutions than just trade. And also for the fans of EU competence theories, which may not be that many in this webinar, but competition is also an area of exclusive competence, which does not become politicized in the same way that, for example, trade policy or a trade defense becomes in certain jurisdiction. And you can apply these disciplines also, for example, on M&A, and so which avoids using national security as a pretext and actually to protect against subsidized entities. And one other element that you can look at is public procurement, which is almost an obsession in EU trade policy, but you can be both offensive as well as defensive at the same time, and basically saying that subsidized entities shouldn't have access to certain kind of our own fiscal spending, if you like. So in other words, you can create leverage for reciprocation in that way, and steer and refine the policy measure towards sectors that have a future value rather than sunset industry in a very creative way.
Clete, we have the last word. Anything more you want to comment on?
No, I think those are all good ideas and suggestions. And again, I think I would just point out, when it comes to domestic, I mean, I can't quite divorce that from the international system. I mean, I think we have updated our laws in the U.S. and as Ron said, there's probably things that we need to do. But even if you look at some of these issues that we're talking about, like currency, I mean, there's no clear understanding of how to deal with that at the WTO. I mean, the rules there really aren't designed for that. And I think, to me, that's where I think more of our focus needs to be at this moment in time. Let's not give up on the international system and just start to do it all ourselves. I'm not saying there's not room for that. And then just a point I'll just reiterate, since I get the last word, is again, we are in a different period of time now in the United States with COVID, with climate issues and all of that. But I just think as we have these conversations and we think about subsidies issues, we just need to continue to distinguish between those that sort of are designed and have international market effects. And I agree with Hosuk. It's not just about sort of trade effects, but it's also like in steel, it's about, distorting prices. But that is what we need to be focused on, I think, more than just, the amount of money going out the door, although they're both relevant factors here. It's really subsidies that distort trade and harm others, as opposed to just simply like we're spending a lot of money on infrastructure in the United States. And I think as we think about ways forward and we think about creating rules of the WTO, I think we can create rules that deal with that distortive effect and still give us the policy space to protect our environment, to build better bridges and roads and everything else.
Okay, well, with that, thank you to the panelists. Thanks to Clarisse for joining us earlier, and a big thanks to our viewers for staying with us. And sorry I didn't get to some of the questions. I think we can all tell from this discussion that this is the beginning of a conversation. And in fact, I'm leaving this discussion thinking there are more elements to this discussion than I thought coming in. But I think we've done a great job in like putting the different elements and aspects of this issue on the table, including the intersection between domestic policy, international policy, non-market economies, COVID, climate, you name it. It seems like all of these issues somehow are implicated in this broader discussion. So with that, thanks everyone. Thanks for joining us. And we look forward to seeing you again next time for another Asia Society event.
Thanks, Wendy. Thanks, everyone.